David, you want to call the roll?
Good morning, everyone. I'll call the roll. Chief Justice Nathan Hack.
Here.
Presiding Judge Sharon Keller. She's here with me.
I see her.
Okay. Mr. Kevin
Here,
Bryant.
I'm here.
There we go. Mr. Kevin Bryant. Miss Sonia Clayton. Senator Brandon Creighton. Mr. John Gimbel.
Here.
Judge Bill Gravel.
Here.
Judge Claudia Laird.
Here.
Chairman Jeff Leach. Judge Missy Maderi.
Here.
Judge Emily Miskell.
Here.
Judge Valencia Nash.
Present.
Judge Kathleen Person.
Present.
Miss Rachel Ratz. Chief Justice Sherry Raddick.
Here.
Mr. Kenneth Sachs.
Here.
Judge Maggie Sawyer. Representative Reggie Smith. Judge Ed Spillane.
Here.
Justice Ken Wise.
Here.
Mr. Evan Young.
Here.
Senator Judith Zaffarini.
Present.
And I believe I saw Miss Sonia Clayton. I think she's in the waiting room. But wait just a second, Chief. I'll verify. Miss Clayton, is that you that just joined? It is Miss Clayton. She's muted, but she's here. Chief, you do have a quorum.
I'm here. Thank you.
Okay, a reminder that the meeting being webcast live and recorded and will be archived as all our meetings are. At the last meeting, I started out by wondering whether 13 months into the pandemic and with vaccines, we weren't beginning to see them. And the answer is no. So we had hoped this meeting would be in person, but believe that the better part of caution here would be to meet on Zoom again, and hope that maybe the next meeting can be in person. So we'll see. But we're able to meet productively and safely this way, and so we're glad for that. We'll have several updates on efforts that we've initiated and have been proceeding on the last few months, especially during the pandemic. And in many of these efforts, as you'll hear, Texas has been a national leader in in innovation and techniques to meet the challenges that we have faced. So it'll be good to hear about that. We'll get an update on the legislative session, and we need to take action on a couple of items. Excuse me. So you've had a chance to see the minutes. Are there any objections or corrections to the minutes? If not, then they'll be approved by acclamation. We'll go to a report of the Indigent Defense Commission. Jeff Burkhardt.
Thank you, Chief. Good morning, everyone. Good to see you. Brief update from TIDC. We have been involved with Operation Lone Star, as has the Office of Court Administration. Pardon me. Our role in that has been to ensure that folks who are indigent receive counsel if they're arrested as part of Operation Lone Star. As part of that, the governor's office granted $1.9 million to TIDC this week. And our board met yesterday and granted those funds to two different organizations to ensure not only that persons receive counsel, but that those attorneys have access to investigators, PDEA attorneys, interpreters, and things like that. So we're very proud to be part of that effort, and that's been going well so far. We did have a board meeting yesterday and a couple brief updates on that. The board granted funding that ensured that 4 more Texas counties will have public defender offices. So we're very excited about that. So for those keeping track at home, we have added public defender offices to 21 counties in the past 2 years. And we've heard great things from judges and county judges and commissioners on the ground. So we're very proud of that. In addition to that, our board renewed the Future Indigent Defense Leaders Program. This is a mentoring, training, and leadership program for new indigent defense attorneys across the state. So we're very happy about that. Last thing I would mention is that we are involved in Child Protective Services case data collection. And our Deputy Director, Wesley Shackelford, who's here with us today, he and I will have an update for you a little bit later to talk about that project. But essentially, we're working with the Office of Court Administration to collect for the first time on a regular basis Child Protective Services data from all 254 counties. So we're pretty excited about that. That's my update, but I'm happy to take any questions you might have.
Thanks, Jeff. Any questions? Thank you. Then we'll have an update on the Uniform Case Management System. Casey.
I have one question. I'm sorry. I
sorry.
couldn't read
Yes.
fast enough. Sorry.
Sure.
My question is, I heard the reference to Operation Lone Star, and all along the border, I don't know if elsewhere in Texas, but along the border, Operation Lone Star is a health services project that includes vaccinations and pap smears and all kinds of testing. Is this related in any way to that Operation Lone Star, or is it just use of the same name?
Senator Zaffarini, I'll take that. I did point out to the Department of State Health Services that there is crossover in those names. Operation Lone Star, there's an agenda item later in the agenda referring to an update on border magistration where I'll talk more in depth about the Operation Lone Star that the judiciary is involved with that Jeff mentioned. So I'll talk a little bit more about that shortly, but it is not the same operation.
All right, thank you.
Thanks, Senator.
Thank you, Senator. We'll go to Casey's report on the case management system.
Thank you, Chief. Thank you, everybody, for having me this morning. I was hopeful that I would be able to give you a better update on the Uniform Case Management System project, but the timing of things, we still haven't gotten our contract or contracts signed yet, so we're unable to tell you who we're awarding that project to at this time. But just so everybody's aware, what this project does is this provides a uniform case management system to our more rural counties. So that's counties with a population of 20,000 or less. It is opt-in, so it's not something that counties are required to use, but it's just another option that if they have a less sophisticated case management system, then they could use the one that we're procuring. One of the great things about this is that it allows them to fully integrate with our e-filing system, because we have reports today that there are a lot of counties that will download files. Some of them will print them out and then scan them back in. And so this kind of does that full integration piece that some of the mid-size and larger counties get. It also integrates with our document access system so that those counties can then expose those documents to the public so that the public can see what's going on in our court system. And finally, the other big piece that this system will do is it'll integrate with the DPS nightly updates so that the court criminal history files, which in some of the more rural counties, clerks have to log into a particular website and key stuff in. And we know that when humans get in the loop, there's a chance for data entry error. And so this system will also integrate with that so that every night it'll automatically upload the criminal history. And Chief, we're hopeful that by next week, we can tell you all more about this project as we make an award on it.
Questions of Casey? This is just such a crucial project. And I just finished my term as president of the National Conference of Chief Justices. And one of the real challenges that we've had throughout the state courts in the whole country has been the lack of information. We just do not have good day-to-day data on how courts are functioning and where problems are. I talked to a Texas district judge this week, and he estimates that he's 6 years behind. I talked to another Texas judge, and he says he's caught up. So it's very difficult to find out where situations exist that need to be addressed, and it will really be good when we get this in place and have better data. We've been working at this a long time. Now we'll go to border magistration, the other Operation Lone Star. David.
Good morning, everyone. And Chief, just for the record, we've had a few people show up since the roll call. I'll just point out for the record, Mr. Kevin Bryant, Chairman Jeff Leach, Judge Maggie Sawyer, and Representative Reggie Smith are all on as well. So just to give you a little bit of an update on the border magistration, which is referred to in the state as Operation Lone Star. A few months ago, Governor Abbott declared a disaster in a number of border counties along the southern border between Texas and Texas on the Mexican border, and began to sort of take actions in relation to that. And then starting in July, the governor's office indicated that he was directing law enforcement to begin making arrests of individuals who were in the country illegally and who were committing offenses that were violations of the state penal code. Primarily, the governor has indicated those would be in the areas of criminal trespass, criminal mischief, and human trafficking, human smuggling related offenses. And so, of course, anyone who is arrested for a state penal code offense that is a jailable offense in particular, all of which those are required to be have certain due process and constitutional rights made available to them. And so, of course, any arrest and any increase in arrest affect the judiciary directly. And so we began working at OCA and with the Supreme Court on and the regional presiding judges on ways to address this. When the the initial discussion was there was not really an understanding of how many arrests this would be per day. Estimates were anywhere from 20 to 50 all the way up to 200 per day. Just to put that in context, if there were 200 arrests per day, that would be 1.4 times the volume of the Harris County misdemeanor courts. So when you're thinking about counties along the border who traditionally don't handle that many cases per year, obviously the impact to the judiciary there is significant. And so the primary place where the arrests began was in Valverde County. And there was a temporary booking facility set up there in Valverde County. And in anticipation of the need to assist the local judiciary there, OCA met with the county court at law judge, which I would just point out there is one county court at law judge in Valverde County, and others from the judiciary there in Valverde County, and began to see what assistance we might be able to provide. And there were really two areas that became readily apparent. In Valverde County, the justices of the peace and the county court at law judge are the ones who typically do magistration. They typically handle about 500 cases per year. And so if you saw volumes in the area of 50 a day to 200 a day, obviously you can imagine the impact on their ability to just handle their existing caseload, much less the additional caseload. And so we worked with the regional presiding judges to get a number of retired judges to be able to be assigned to sit as visiting judges to hear magistration in these cases. And so Chief Justice Hecht signed an order back in early July appointing about 30 judges across the state to sit as visiting judges to hear that. So basically relieving the burden from the local judges there to do that. Of course, if you're unfamiliar with that process, basically when someone's arrested for a misdemeanor or a felony, they're supposed to be taken before a magistrate in the state within 48 hours. But if that's a misdemeanor offense, which so far all of the arrests related to Operation Lone Star have been, then they have to be taken before a magistrate within 24 hours to determine probable cause, because if not, the individual is required to be released on a personal bond because they have not been found, there's not been probable cause found. And so every single one of these arrests must be taken before a magistrate within 24 hours. At that magistration, sometimes referred to as the 1517 hearing, referring to the article in the Code of Criminal Procedure, the magistrate has to do a number of things. One, inform them of their rights, things like rights to counsel, rights to terminate interviews, things along those lines. And then also to determine whether or not they are entitled to appointed counsel, which so far all the ones that our magistrates have done have been indigent and have been entitled to appointed counsel. Of course, if they're entitled to appointed counsel, appoint them an attorney or ensure that that appointment is made. Set bail for the individuals, and then determine whether or not consular notification is required under the Vienna Convention. That's basically a requirement to notify the country in which they are citizens that they've been arrested in the United States. Most of those are voluntary notifications, so it's basically up to the individual who's been arrested as to whether or not that is done. So these 30 judges are from all over the state, and we have worked with the local jail there to set up a way to do this magistration remotely. So basically the judges are able to log into a system and then review all the paperwork, sign the paperwork, have face-to-face communication, video and audio with the individuals who've been arrested. And so that process has been working well. Of course, some of the complications with this are, one, interpreters. The individuals primarily who've been arrested primarily speak Spanish, but we've also had some French speakers and others. And so we've been providing interpreters. OCA has 2 on-staff Spanish interpreters, and some of you have used them before. We made great use of them. We've added a 3rd one recently, made great use of that one. But then just most recently, we've signed contracts with a few more. As you can imagine, magistrations are occurring up to 3 times a day, 7 days a week. And so trying to make sure we have enough interpreters to cover that is also important. We're also looking to add a couple of staff. As you can imagine, it takes some staff resources from OCA to assist with this. So we're actually working to cover that as well. And then lastly, and perhaps maybe the biggest challenge for us so far, which Jeff mentioned in his report, is that the right to counsel and making sure that there are attorneys to represent individuals who are entitled to appointed counsel. So far, well, I should say that in Val Verde County, on their court-appointed list, they have 9 lawyers who generally serve misdemeanor cases, as you can imagine, with volumes that we were expecting, and them already having caseloads in state and federal court. There was not capacity to take on additional cases, which is the reason why TIDC's efforts to fund counsel and try to assist in making counsel available has been so critical. So far, the majority of those cases have been appointed attorneys from the Texas Rio Grande Legal Aid Public Defender Office, and then now those are transitioning to other lawyers appointed as well. So far, there have been 434 arrests since July the 20th when the operation began, so a month ago. Thankfully, at least from the judicial perspective and resources perspective, it didn't start out at 200 per day, which would have been very difficult. But that number is increasing daily. We've seen now the arrests are happening both in Val Verde County and in Kinney County, which is next to Val Verde County. And so far, we've been working with the local judiciary in Kinney County to set up a process to assist them as well. About 200 of those arrests have been in Val Verde County. The other 234 have been in Kinney County, and the volume there has been heavier in recent days. So that's basically what's going on with the process. Let me give you a little bit of background about the cost. As you can imagine, there is a need for some funding to cover this. 1, covering the visiting judges, 2, covering interpreters, and 3, the other primary expense is in the area of indigent defense. The county there in Val Verde County, normally only handling 500 cases. You can imagine the cost to them to do 500 cases per year. The cost to them would be significant to do this if they were having to pay for those as they typically do. So we have asked the legislature and the governor's office for funding to assist in this. And so far, the governor's office has provided to OCA funding to cover the cost of the operation expenses from the judiciary side through at least September 15th. It's likely that that will be able to extend a little bit longer than that, but that's that. And then just yesterday in the House, there was a appropriations bill filed. It's House Bill 9. And that bill is anticipated to be heard in the next few days. And that will provide a annual funding to OCA of $32.5 million. That will cover the annualized cost of visiting judges, interpreters, staff expenses, and then also indigent defense costs. So ultimately, the thought here is that it would cover all of the costs that are associated with the operation. I think that's basically it. I don't think I've forgot anything, but I am certainly happy to answer any questions that you may have on this. I should say that out of the 434 arrests, 100% of those arrests have been for criminal trespass, which is typically a Class B misdemeanor. But when that offense is committed in a disaster area, which so far all of those have been because of the declared disaster, then it is a Class A misdemeanor, which is punishable by jail up to a year and a $4,000 fine. So at this point, I looked out of those 434 cases, 38 of those cases have been resolved at this point. And I believe most of those were done by a guilty plea in the last couple of weeks, where the individuals were sentenced to time served, 15 days time served, and then released into the custody of the federal ICE officials. And a few of the cases were dismissed for various reasons. So with that, I'm happy to answer any questions you might have.
Let me just add before we go to questions that of course, as you all know, the initiative has engendered some controversy in the public discourse, and the judiciary takes no part in that. We're just trying to make sure that the courts function well, that they have the resources that they need, and that defendants' rights are protected in arraignments and appointed counsel. So we just try to make sure that all of those bases were covered, given the otherwise limited judicial resources in those counties. Senator, I think you had your hand up.
Yes, Chief, I did. Thank you so much for allowing me to ask some questions. David, first of all, who is making these arrests?
I believe it's primarily the Department of Public Safety, but I don't believe there's any prohibition on anyone else. You know, obviously, if the law enforcement encounters someone who has committed an offense, any law enforcement officer would be entitled to. But I believe most of the arrests, if not all of them, have occurred by the Department of Public Safety.
So those would be our highway troopers.
That's correct.
So basically, then, do you know if these troopers are being taken away from highway patrol duties to do this?
I don't know the answer to that, Senator.
And I understood from your report that these are new arrests, additional arrests being made, not simply the same number of arrests being done by different groups of people, for example, in the troopers.
That's correct. You know, just to compare volume in a typical year in Val Verde County, they typically do 500 total cases. That's counting misdemeanors and felonies, 500 total. And as I looked this morning, from July 20th until today, or I guess till yesterday, there were right at 200 arrests for new misdemeanors in that county. And then there were around 230 in Kinney County. And I don't have the numbers to tell you what their typical volume is, but again, it would be, this number would be significantly higher than their normal arrest volume.
And where are the judges who are being assigned by OCA performing their duties?
They are performing their duties from primarily from their homes or their office locations. They are assigned judges and they are participating remotely through video technology. Article 1517 of the Code of Criminal Procedure provides, and it's been in statute for some time, that basically someone arrested is to be taken before a magistrate in the state, anywhere in the state, for expediency, and that can be done remotely via video technology. So That statute is already there. I know you had a bill to try to allow similar things in all areas, but this one was already in place. And so that's what we're using to be able to accomplish that duty.
Well, if the judges are working remotely, I think that's great. Where are the persons who were arrested being processed?
They are being, the ones in Valverde County are being processed in a temporary booking facility that was built in Valverde County near the sheriff's office. It's in Del Rio. It is, the best way to describe it is it's basically kind of Senator, you would know like what the testing facility looked like outside the Capitol, sort of like a tent-like structure. And they're held there. They can only be held there for up to 24 hours because it's not a true holding facility, similar to maybe like city jails where they only have, there's not beds and places for them to sleep there. So they're held there temporarily. Our magistrates determine probable cause, set bail, read them their rights, appoint counsel, all of that. And then they are transferred from that facility in Valverde to a more permanent holding facility in Frio County at Briscoe, the Briscoe unit, which was formerly a TDCJ prison, which has been converted at this point to be a jail holding facility for more permanent holding.
And you believe that the funding will be provided through this House bill that was just filed?
The funding that we have asked for, I just saw the House bill this morning. I looked, the numbers that are included in House Bill 9 are 100% of the money, the amounts that we asked for to cover the judiciary related cost. Obviously, as you know, that has to go through both the House and the Senate and be signed by the governor. But and of course, our portion of that is a small portion. I think the number is somewhere over $1 billion. I think maybe $1.7 billion in that funding bill. OCA's portion is $32.5 million. So, obviously there'll be some discussion about that in the House and the Senate over the next several weeks. But if it were to be passed as it is, it would cover 100% of the requests from OCA.
Thank you so much. Nobody I know supports illegal entry into the country. Everybody supports legal immigration. Well, some people support legal immigration from Mexico. Others do not. Others consider that controversial for whatever reason. But I would just hope that all the judges involved take extra care to ensure that language used be measured and appropriate, and not to use hysterical terms such as invasion. There are people who enter this country for a purpose, usually related to education and jobs. Perhaps they're afraid of the cartels or whatever reason, but we shouldn't use words like invasion. That's what the controversy is, partly, that the chief referred to earlier. So I would hope that all the judges would ensure that language be measured and that appropriate terms be used, such as undocumented persons, not illegal aliens. You all know better than I that persons are not illegal, their actions are. Thank you.
Thank you, Senator. One thing I would just say is I've personally observed several hours of these hearings with our judges, and we did a training with them up front. And I can assure you, these are some of the best judges that we have in our state. For sure, of course, all of our judges are great judges, but some of the most long tenured great judges who agreed to take on this assignment. And my perspective is they're doing exactly what the chief described earlier, which is the judiciary has a job to do, and they're doing it and doing it well. So I'm really proud of the work that they've done so far and what they will do.
Thank you.
Now, they seem to be actually bending overboard to, not that judges don't do a good job all the time, but they're taking extra care given that it's a special assignment. Other questions? Well, thanks, David. And we'll keep you apprised. The Indigent Defense Commission and the local governments have been working to make sure that the process is in place for appointing counsel. We're going to work in this situation. And so we're really glad that they've been able to work out those wrinkles as well. We'll go to the, excuse me, eviction diversion program. So let me just remind you of a little history. When the pandemic was started and the disaster was declared March 13 of last year, the court immediately issued an emergency order, and I met with legal aid representatives and representatives of landlords, and without too much argument or dissent in those discussions, it seemed clear that a moratorium on evictions was going to be necessary for everyone to just kind of get their bearings. So that's what we did. And by May, it looked like the pandemic was going to be with us a while. And so probably a moratorium was not going to work going forward. We need to find other ways to meet the situation. So we lifted the moratorium in the court's emergency order. There were other moratoria in place over the months, as you know, both involving the CARES Act and CDC and some controversies about all of those things. But there was some effort to resume evictions cases at some level. So I also appointed a working group for the justices of the peace that included lawyers who routinely represent tenants and landlords to identify procedures that they needed to have to make the process work better that don't exist, such as, for example, excuse me, requiring that both landlords and tenants are aware of other avenues that may impact the proceedings, like the moratorium, like the eviction diversion program, which we'll talk about here in just a second. And so they continue to work and have been extremely helpful and productive in identifying small things about their procedures that we can help them with, the court can, and just make it easier on them in these cases, which are already hard. I don't need to say that evictions are hard on tenants and landlords alike. They're also hard on society. And so it is truly a big problem for all of us during the pandemic. It's true in every state. And 3 or 4 weeks ago, Attorney General Garland asked to meet with all of the chief justices of the states, and we agreed to, and we had 37 on the call. And I don't recall ever having a call with anybody like that ever, but it was very constructive. And he offered the services of his office to try to help processes that affect evictions. Like, for example, sometimes when funding becomes available for a diversion program, access to it can be very complicated because of the application and red tape that the government makes you jump through to get to the money. And that discourages landlords and tenants alike. And so he's helping with that in several other ways. But we are glad to have his assistance in this, and he seems to be glad to have ours. So as a result of that meeting, the Conference of Chief Justices decided that what we needed on a national level was a team dedicated to addressing these issues separately. So we've had a rapid response team throughout the pandemic that meets every week, and I chair it, and it goes through every issue from soup to nuts, jury trials and remote proceedings and HR matters and all vaccines and all kinds of issues that have come up during the pandemic, and try to find out what states are doing and then get information out to everybody so they can decide what they should do in their own jurisdiction. So we've been doing that since the pandemic began. And now we've created an RRT, rapid response team, just for evictions. And I'll be on it, as well as the Chief Justices of Indiana, Michigan, and Massachusetts. And we'll be doing the same thing. We'll be gathering up information and trying to get the judges who handle these cases as much help as we can across the country. And in the course of that, we're also wondering how this might change the face of eviction proceedings going forward. And so we'll be considering that as well. I think a lot of jurisdictions have some thoughts on that and some ideas about changes they might want to make. And this group helps everybody communicate, so we're not reinventing the wheel all of the time. And states that have fewer assets to devote to issues like this won't be disadvantaged. But now let's have David tell you about our eviction diversion program.
Thanks very much, Chief. I've got a presentation here I'm going to share with you all. If someone can give me the thumbs up, I'll know you can see what I'm doing. Okay, great, thanks. As the Chief mentioned, this is an area where I just have to stop and sort of brag on Texas for a minute. There was an article published last week that said that of all of the rental assistance money that has been provided by the federal government, which is now over $47 billion, that only 7% of that money has made it to landlords and tenants to assist them. And there's a lot of frustration at the federal level about why that is. I checked this morning, and you'll see these numbers in a second. Texas has distributed over 62% of its money and is leading the country in the distribution of the funds to landlords and tenants. And so I think, we have Monica McCarthy, who is working on the eviction diversion program from the Department of Housing and Community Affairs here at the state level on today. But I just want to say to everyone that working collaboratively between the executive and judicial branches with the governor, the Department of Housing and Community Affairs, and the judiciary has really paid off benefits, and other states are looking to us for how we're doing that. This presentation I'm giving you today I actually gave on Tuesday to the Indiana task force because they were trying to figure out how they could replicate our program to be successful. So I just point that out to say we should be proud of the work that's been done so far. So just to give you a little bit of background, the eviction diversion program began as a pilot in October of 2020. It was a collaboration between the Supreme Court, the governor, and the Department of Housing and Community Affairs. And it was established by a Supreme Court order, an emergency order, that basically laid out the parameters of who would participate, how the process would work, which we'll go through in a minute. We began working with justices of the peace who hear these cases all over the state. There were about 19 counties originally in the pilot program, and using feedback from them, we were able to make changes. Ultimately, the program, after making those changes and working with those pilot counties, became statewide in February of 2021. And there was $1.2 billion provided in rental assistance from the federal government to the state that are being used to provide rental assistance generally. But of that $1.2 billion, TDHCA and their board set aside 10% of that money, or $117 million, to be used for households who had already been sued for eviction. So that was a floor, the $117 million, and we'll talk about where we're at now on that. But basically, there was a pretty strong commitment at the state level to making sure that there was funding available to assist when there was an eviction case filed out of that. Remarkably, in Texas, we offer the maximum amount of rental assistance to individuals and to utility assistance. So it's 15 up to 15 months of rental assistance, 12 months backwards of arrears, and up to 3 months forward, and then some combination of back utility payments and forward utilities. I should point out, of course, that these are all situations that are related to COVID. So individuals who have been impacted either by a loss of a job or had to be out time that caused them to get behind on rent because of the illness or other reasons, but it has to be related to that. So basically, who's eligible? Of course, landlords and tenants are eligible. The eligibility criteria is pretty simple from a landlord perspective. It's for assistance from non-payment of rent that goes back to March 13th of 2020, the day that the state and federal government declared disasters and emergencies related to COVID. And then landlords have to have a bank account and accept direct deposit. These funds go primarily directly to landlords to pay off the debt. From a tenant perspective, they have to have been sued for the eviction diversion program. They have to have been sued for eviction. They have to have income at or below 80% of the area median income, which is a specific number in different areas of the state. They have to have either qualified for unemployment benefits sometime during the period or experienced a significant reduction in household income or financial hardship during the pandemic. And then they have to provide either an eviction notice or a past due utility or certify that without the assistance, they're going to ultimately end up in an unsafe or unhealthy environment. So that's sort of the basic requirements of participation. When a landlord or tenant applies, they have to provide certain information. And one thing I would say, again, Texas leading the way here, TDHCA has worked really hard to simplify the application. Many of the states are struggling getting money out the door because applicants just cannot make it through the application process. And so you'll see here, it's pretty straightforward. They have to have an ID, landlords and tenants. The landlord needs to provide either a lease agreement or at least certify the term of the lease and the amount, and sort of vice versa with the tenant. They have to provide the lease agreement or at least some proof of the amount of rent they were paying. Landlords had to provide a W-9 to receive the funds, and of course that direct deposit information. Tenants had to provide a court docket number if they have one, and any past due utility bills if they're seeking utility assistance. That's pretty much the application process. Once they do that, they make certain certifications. I'm not going to read all of these, but the key ones from a landlord perspective are that they will waive any certain fees and penalties, and also not pass on court fees to the tenant, and that they won't evict the person during the period of time that's covered by the eviction diversion program. So basically, sort of in exchange for getting the past due rent paid, the arrears, and even forward rent, they will agree to sort of waive everything and let them stay housed in that location. Tenants have to certify that they're at or below the income levels, and that they've not received rental assistance during that period of time. I'm not going to read all of this. I wanted to provide it to you, and we'll make sure you get a copy of this presentation. But the Supreme Court's order lays out certain requirements for all justice courts in the state. And their most recent order was issued on July the 19th, the 39th emergency order. And it does a couple of things. It requires that petitions from landlords for eviction have to include a statement that they've reviewed the eviction diversion program information. The goal here is to make sure they're aware that rental assistance is out there and that they're not required to evict. They could choose to get rental assistance to cover the debt. And so that's just really kind of an informational perspective for landlords. When the citations or the notices of the eviction proceedings are issued to the tenant, they have to provide certain language in the citation. I've actually got it for you here. It's in English and Spanish. And basically, with that, it tells them that they could stop their eviction and get the rent that they owe paid if they were to participate. It refers them to a brochure that's attached to the citation that gives information about the program that TDHCA developed, and refers them to legal aid resources that might be available to them as well. So once that information is provided, both the landlord and tenant, once the individuals show up for the trial date, which generally occurs sometime between 14 and 21 days after the case is filed, then the judge is required to discuss the program with both the landlord and tenant. inquire about their interest in participating, and also inquire whether or not the landlord has any pending rental assistance applications. If the answer to that is yes, the landlord and tenant do want to participate in the program, or if the answer is the landlord has a pending rental assistance application, the judge is required to abate the case or stop the case for 60 days, make the case confidential so that it doesn't show up on the record of the tenant, and then inform them about how to reinstate the case anytime during that 60-day period. At the end of the 60-day period, assuming everything goes well and the rental assistance comes through, then the judge is required to dismiss the case with prejudice and keep all the records confidential. But if the landlord or the tenant at any time wants to reinstate the case and go ahead with the eviction, they're allowed to do so. And the order provides a process for doing that, including making the records, again, non-confidential, and then trying the case within 21 days of that. So basically it gives them that chance. So this is just a quick little way to view what I said graphically. I'm not going to ask you to look at this. It sort of breaks it down into 3 phases. In the pre-hearing, of course, basically, again, there's an eviction issue. The landlord files the suit that includes that information that they've reviewed the program. The citation gets issued with that language. At the hearing, basically, they have a choice to make whether to participate or not, and judges will go down the path that they want. If the landlord and the tenant don't both want to participate in the program, the case proceeds as it normally would with an eviction, and the judge will just make a decision based upon the law and the evidence. And then after the hearing, basically, either the case is diverted, and so the funding comes through and the JP dismisses the case, or it either comes back into the court through the reinstatement process and they proceed as they would have otherwise. Another couple of things that are important about the program is that the role of legal aid has been something that has been recognized throughout. During the pilot phase, there was some funding provided by the governor's office to provide legal aid. $4 million was provided to assist with providing legal aid related to rental issues and other issues. And since in June, TDHCA actually allocated $20 million to legal aid to assist with providing assistance with rental assistance. To put that in perspective, that is more than the amount that is appropriated by the legislature for legal aid. So it is a significant infusion of money. And the goal is to make sure that in our almost 900 justice courts across the state that are hearing evictions, that there would be legal aid available in every courtroom, either virtually or physically. So that's still being rolled out, but that's the goal, is to make sure tenants have access to counsel and landlords have access to information that can be provided as well from legal aid resources. I took this snapshot off of the website this morning. You too can go look at this information anytime you want. If you go to texasrentrelief.com, that is the rent relief statewide portal where landlords and tenants can apply, seek information about their status, their application, but it also provides at the very top a link to data, which I find quite interesting. And this is as of this morning. Actually, I guess it's as of yesterday at 4:50. It's probably been updated while we've been on this meeting even. But you'll see that the state has allocated, either paid or in the process of paying, over $726 million out of the 1.2 billion that's available. So it's over 62% of the funds distributed. And over 120,000 households have been assisted with that. The average assistance about $6,000. You can see the primary distribution of the funds has been to arrears. This is obviously making landlords whole and keeping tenants housed, but it's also a significant amount of the money has been for rental assistance going forward. So making sure that not only are we covering arrears, we're also keeping people stable in the house so that the landlord can count on funding to pay the future months up to 3 months, and that the tenant can cover those and kind of get back on their feet. Also, you see some utility assistance as well. If you clicked on the geographic information, which I don't have a picture of for you today, you would see that every single county in the state there's been funds distributed to at least one household in every county in the state. So it is truly a statewide program that's been very successful. I want to show you just some demographic information. I won't go through all this, but I just think it's kind of interesting to look at. This is for the broad rent relief program. You'll see the amount of money that's been distributed by per household. If you look at the upper right, you'll see the area media income, that the majority of the people, almost 57% of the people who received assistance, have received, that those folks are below 30% of the area median income, which would be the poorest folks in our state. So you see that's where primarily where that money is going. You can also see the ethnicity and the racial breakdown of where the funding has gone. Again, I find this to be an interesting piece of information. So that's on the ROD rent relief program. I wanted to just show you just eviction diversion because I think this is obviously the key for the judiciary. I mentioned to you that TDHCA had set aside $117 million of that $1.2 billion. And you can see that we are now, as of this morning, at somewhere around $104 million have been expended. TDHCA has said that this is the floor, so not to say we're about to run out of money overall, but there's been a lot of money distributed just specifically from eviction diversion. These are people who had eviction cases pending and were provided funding. You can see over 12,000 households, and those of you that work in justice courts or around justice courts know that it's likely that the majority of those people would have been evicted. Many cases where evictions are filed, those individuals end up being evicted. So I sort of looked at it as a measure of people who were able to stay in houses just because of that. Again, you can see the majority of the money, it looks a little different on this slide. Majority of the money from this program has been distributed for arrears, which makes sense since it's an eviction proceeding, but there's still forward money in the rental assistance being provided. And again, the breakdown by demographics just for eviction diversion, you can see that the amount of the payments has been larger in eviction diversion than it has been in the broader rent relief program, but otherwise you see pretty much things look pretty similar in the area median income and the ethnicity and race statistics overall. So with that, I'll stop sharing my screen, and I wanted just to turn it briefly, if I could, to Monica McCarthy from the Department of Housing and Community Affairs. She has been a great partner, and TDHCA and their leadership and their board have been awesome to work with. We meet regularly to talk about issues and try to make the program better. And I just wanted to turn to her for a second to see if she had anything she wanted to add. So Monica.
Thank you so much, David. Yeah, I really, on behalf of TDHCA, would just like to underscore everything that David said around the partnership and collaboration with the justice courts has been really critical in allowing us to expand the awareness around the availability of the rental assistance, and also to reach the scale that he was just describing to you now. And similarly, input and collaboration from everyone from legal aid to landlords to the courts has allowed us to improve this program and do our best to meet the need that is out there. Yeah, so thank you, David.
Chief, we're happy to answer any questions if anyone has any.
Questions for David?
I have one.
Yes, Senator.
Sorry, I always have questions, but these presentations always get me thinking. And my question is, you said that Texas is at the forefront and you're so proud of Texas being at the forefront in this effort. Who's responsible for that? Is it federal funding? Is it the agency? Is it the Supreme Court order? Who is responsible for our being at the forefront?
I'm happy to hear Monica's take on this too, but what I would say is it's all of the above. The funding for this, it started as a collaboration of some of the CARES money that was provided by the federal government to the state, but the state made the active choice, and it involved legislative leadership at the time because it was during the interim, as well as the governor and TDHCA and OCA and Supreme Court working together to say we really need to do something. This was back in October of 2020, before really there was a lot of focus on eviction diversion in the country, and so there was an active choice made to do that, and that was sort of the beginning. Of course, the primary source of the money, well, I guess all the money right now is coming from federal funds at this point related to the money I'm referring to still as the December stimulus money. There will be more coming from the more recent, I think March or April federal money. So it's really that. But I do really, I mean, I don't want to underestimate the impact of the collaboration between the TDHCA, the Supreme Court and OCA, and the governor's office, and the justice courts. I mean, I think, and legal aid, I mean, I could probably keep naming people, but it's really been collaborative. And as I mentioned, I did this presentation for Indiana earlier this week, and the real issue in many of the other states is there's not that collaboration going on. And so you've got the their housing authority out there trying to figure out how to do this, but there's no discussion going on with the courts. And then the courts are really frustrated because they don't know what's going on or what to do with folks. And so, I think what Attorney General Merrick Garland was really trying to push the chiefs to do when he met with them last week was to really try to engage and make this really be a program that works in every state. But I just really have to brag on the collaboration. I think that's been essential. And we've got, and what I would just urge everyone to is you all have connections in your communities. Spreading the word is important. Making sure people know this is available. Lots of people are hurting, whether you're a landlord or a tenant. And so making sure that they're aware this is available to them, I think has been really key. So Monica, do you have any, I don't know if you want to have any other answer to the question from Senator Zachary?
Mostly, yeah, second what you said, the availability of the funding has really, and just the urgency of the need has brought all the stakeholders together. And the fact that we've just never operated at this scale before, and having a statewide program has been, I think, helpful in streamlining, just letting people know how to access what is out there.
Well, thank you for your answer. I believe in giving credit where credit is due, and that's very impressive. And while you were talking, David, you reminded me of the time that you and I believe the chief joined us on that panel too, at a national conference in Austin. And the people from outside Texas were amazed at the collaboration between the executive, judicial, and legislative branches. And they asked how we did that. And frankly, my answer is we did it through OCA. So thank you and your staff for that leadership.
Thank you, Senator.
David, I'd like to say something.
Sure, Judge.
So kudos to the TDHCA and the stakeholders and OCA, because on the ground level as a JP, 62% or whatever that percentage was, I have people, defendants, tenants coming back into my office, coming and saying, this is like a breath of fresh air and it lets us move on. And so that is just amazing, the work that has gone into this. And also to the training center who has offered to the courts, the justice courts, the script where we put this back onto the two parties and the language in the petition from the onset that says this is available. So it has just let us give more access to justice on the ground level. And so thank you to all of you.
Thank you, Judge Sawyer. I think Judge Nash has her hand up, Chief.
Oh, thank you, David. I kind of, Judge Sawyer said what I wanted to say, which is, we had our challenges at first. And I think a lot of the landlords just wanted to know when the check was going to be cut. And we have had the benefit in Dallas County to have legal aid on site for over a year. And that has helped us tremendously so that, tenants can have the accessibility to be able to walk through the paperwork and the things that are necessary. And so, David, you did say something that was key, which was we really do have to give other tenants the information, because a lot of people, some of them are not showing up and they could really have the benefit of this program. So I am really happy about where we started and where we have come to now. But I think certainly there is just a little more that can be done to even see some huge and larger benefits for this program. But now I have recognized in my court that a lot of landlords are now very much willing to agree to go into these rent relief programs, and we're excited about that. And so the community I serve, I'm really happy to know that, but I certainly would like to make sure that we can get more information out to tenants. And even if that's landlords providing a deficiency list of tenants who may have had those issues and they know about them because they're directly working with them more than the courts. But it would be nice to see a list and maybe be able to help more people than we have. But thank you so much for all the efforts put into this. We are certainly seeing the benefits.
Any other questions or comments?
Judge Laird has her hand up too, Chief.
Oh, sorry. Yes.
Thank you, Chief. David, I get these on trials de novo on appeal. Should I be referring pro se tenants to legal aid directly to inquire about representation, or is that not how this is designed?
The answer to that is yes. You can make sure that they know that legal aid resources are available. The Supreme Court a few months ago actually amended the order to make sure that provisions that apply on the original trial in the JP courts also apply on the trial de novo on an appeal in the county court or county court of law. So really everything I went through and discussed that's available on the justice courts and the requirements apply at the county court or the county court at law level as well. And your legal aid resources should be available to you in a county court of law as well, Judge Laird.
Thank you.
Well, thanks to our judges on the front line. And I'll just add, since we've talked sort of philosophically at the end about the importance of collaboration with the other branches and amongst each other, I will say also that when I started in the trial court 40 years ago, judges really saw their role exclusively as presiding over cases. And the only institutional issues we ever addressed were the budget. And that was pretty much it. But as time has evolved, the third branch has realized that we have some responsibility for the health and strength of our institutions and of the branch. And so we can, these kinds of things that we're doing, which might have seemed outside our scope even a decade ago, are now happening pretty routinely, and it really benefits the justice system, and it's really made a big difference. Well, thanks for that, David. Let's go to the legislative update. Megan Lavoie.
Good morning, everyone. I'm happy to be here to provide you with a brief update on the 87th regular legislative session and what we are watching as we head into the latter portion of the second week of the second called special session this summer. It has been quiet the last few weeks with the House lacking a quorum to do business, but late yesterday, the House did indeed get a quorum, and we will be seeing a lot of action at the Capitol in the next few days. But let's get back to May and do a quick recap of the 87th regular legislative session. As you recall, the 87th session started slow. And Kelly, if you can, yes, there you go. As the pandemic delayed the naming of committees and commencement of committee hearings, the pandemic had an impact on bill filings too. You can see there were roughly 400 fewer bills filed during the 87th session compared to the 86th, and roughly 350 fewer bills passed both chambers. The governor also vetoed fewer bills this session, 21 compared to 56 in 2019. The legislature appropriated more than $796 million to fund the judicial branch for the 2022-2023 biennium. This funding level is roughly $60 million less, or 7% biennial decrease from the 2020-2021 spending levels. The funding supports the Texas Supreme Court, Court of Criminal Appeals, appellate courts, and judicial branch agencies, boards, and commissions. The appropriations in Senate Bill 1 included more than $94 million over the biennium for indigent defense funding and $76 million for basic civil legal services. So it's always been the tradition for the chairs of the House and Senate committees with jurisdiction over the judiciary to sponsor a judicial omnibus bill every legislative session with new courts, jurisdiction changes, and modifications to judicial operations. House Bill 3774 by Representative Leach and Senator Huffman was the 87th legislature's judicial omnibus bill. The bill created 10 new district courts, 6 new county courts at law, and 1 statutory probate court. The courts will all come online over the next biennium. Upon request, the Office of Court Administration provides a detailed workload analysis to the legislature that justifies the creation of each new court. Moving on to recommendations from the council that made it through the process and were signed by the governor. First up are recommendations from the Civil Justice Committee. The economic hardship caused by the pandemic and Winter Storm Uri made modernizing wage garnishment and seizure laws to protect wages earned by Texas workers imperative. House Bill 3774 creates an easy to navigate process for people to challenge wrongful seizure of exempt funds. It requires the Texas Supreme Court to establish rules to govern how a person can challenge a wrongful seizure. It requires the debtor to be notified in plain language that their account has been frozen or seized, and it requires the debtor to be given information on how to find free or low-cost legal help. The council's recommendations to modernize the civil filing fee system, similar to the changes to the criminal court costs bill last session, were included in Senate Bill 41 by Senator Zaffarini and Representative Leach. Beginning in January of 2022, civil filing fees across the state and in most case types will be the same. Filing fees for civil cases in all district courts, statutory county courts, constitutional county courts will be $350 for the filing of new cases and $80 on the filing of other actions, such as an appeal, counterclaim, or cross action. Justice court filing fees will be $54 for all civil filings. Moving on to the council's recommendations on guardianship and mental health that were signed into law. House Bill 79 by Representative Murr and Senator Zaffarini establishes a framework to create specialized courts to hear guardianship cases, similar to our child protection courts. If you will remember, a similar bill made it through the process last session, but was vetoed by the governor. Thanks to the hard work of Senator Zaffarini and Representative Murr and the council, the bill was not vetoed this time and had overwhelming support. Senate Bill 49 by Senator Zaffarini and Representative Murr is what we refer to as the Mental Health Omnibus Bill because it contained 9 of the Judicial Commission on Mental Health's recommendations. The legislation includes clarification of time periods for competency orders and provisions to streamline jail-based competency restoration pilot programs. Many of the provisions are changes to improve practical and implementation problems observed by members of the Mental Health Commission's Legislative Committee, who are experts in the field, of course. Other bills of interest, SJR 47, this is the proposed constitutional amendment, which would change the eligibility requirements to be a judge. It raises it to 10 years of experience as a Texas judge or practicing lawyer in the state, or a combination of the two for the appellate courts, and 8 years as a Texas judge or practicing lawyer in the state, or a combination of the two to be a district judge. The amendment would prohibit a judge or justice from running for election or being eligible for appointment if their license to practice law was revoked, suspended, or subject to probation. If this is passed by voters during the November 2nd election this year, the amendment will become effective January 1st of 2022 and would apply to judges and justices elected or appointed after January 1st of 2025. Funding for specialty courts like drug and DWI courts across the state has historically been limited. House Bill 1256 develops a new funding source by requiring that 1% of the mixed beverage gross receipts and sale taxes received by the state, which is estimated to be around $10 million per year, be credited to the GR Specialty Court account. Funds generated in this account may only be used by the Criminal Justice Division in the governor's office for distribution to specialty court programs that apply for the funding. More bills of interest. It's common practice for us to receive text notifications reminding you of an upcoming appointment or package delivery. But what about court dates? Well, House Bill 4293 requires the Office of Court Administration to develop and make available to each county a court reminder program that would send a text message to notify criminal defendants of scheduled court appearances. Similar programs across the country have reported great success in reducing failure to appear rates using programs like this. Senate Bill 907 requires the Texas Judicial Council, so a little bit of work for y'all to promulgate rules in consultation with the Department of State Health Services to develop and implement a voluntary certification process where a county clerk may be certified to issue a marriage license to applicants through remotely. The bill requires procedures to authenticate each applicant's age and identity to prevent any fraud. So what didn't pass from the council's recommendations? First up, Senate Bill 690 by Senator Zaffarini and House Bill 3611 by Representative Leach. Those were filed to remove any statutory barriers to continue remote proceedings after the state's COVID-19 disaster declarations and Supreme Court emergency orders expire. We had many stakeholder sessions with a variety of groups, including prosecutors, defense attorneys, the Family Law Foundation, Access to Justice, and many more concerning this legislation. The main sticking point seemed to be that some of the stakeholders wanted consent of the parties to proceed remotely. We will hear, I believe, from Chief Justice Heck here shortly on a charge for the Judicial Council to continue to monitor this issue. Senate Bill 1740 contained the council's recommendations related to civic education. That bill was referred to the Senate Education Committee, but didn't receive a hearing. The council's recommendations on bail were contained in House Bill 20 by Representative Murr and HJR 4 by Representative Casal. Both passed the House and the Senate, but ran out of time when the conference committee reports were not adopted on the last night of the session. Bail reform was added to the call of the first special session and the second special session. The bail bills for this special session are House Bill 12 and Senate Bill 6. The constitutional amendment is in SJR 3 and HJR 1. The Senate has passed Senate Bill 6 and SJR 3. Yesterday afternoon, after several weeks of lacking a quorum, the House did establish a quorum, and SJR 3 was heard this morning in the Select Committee on Constitutional Rights and Remedies. They had a formal hearing and passed the constitutional amendment out of the committee 10-0. The hearing on Senate Bill 6 in the House committee is actually scheduled for tomorrow morning at 9 a.m. Senate Bill 6 by Senator Huffman and Representative Smith contain most of the council's bail recommendations, with the exception of requiring judges to use a pretrial risk assessment. Instead, it requires OCA to develop a public safety report system and make it available to judges to use in setting bail. The system would include the defendant's criminal history in a summary form, but it would not assess risk. Another carryover from the 86th session was the council's youth class C diversion legislation. If you recall, the bill passed the House last session, but made it over to the Senate too late in the process for a hearing. It was the same song and dance during the 87th session. The bill did not pass the House. The bill did pass the House, excuse me, and it did pass out of the Senate Committee on Criminal Justice, but never made it to the floor of the Senate for debate. More bills that didn't pass. House Bill 1875 by Representative Landgraf would have established a business court and business court of appeals. Senate Bill 1511 by Senator Zaffarini and House Bill 3977 by Representative Moody contained the Judicial Commission on Mental Health's recommendations related to emergency detention procedures. Moving on, Senate Bill 11, we're lagging just a little bit behind, would have reorganized the Court of Appeals from 14 courts to 7. And Senate Bill 1529 would have created the Texas Court of Appeals. That would have been a statewide Court of Appeals that would have had exclusive appellate jurisdiction over all civil cases brought by or against the state or state agency, board, or commission, or by or against an officer of this state. So where are we today? Like I mentioned just a bit ago, we are in the middle of the second called special session. The House has been at a standstill as it waited for members to return to the chamber to make a quorum. The quorum was met yesterday afternoon, and the House has immediately gotten to work with hearings this morning, passing out that SJR 3. In addition to bail and border funding, which David talked about earlier in the meeting, we were also asking for additional funding to support visiting judges to help deal with the COVID-19 backlog. So lots of action going on and going to be happening over the next several days. And we'll be sure to provide another legislative update via email once these bills start moving through the process. I'm happy to answer any questions that y'all might have.
Thanks, Megan. Questions of Megan? We want to thank our legislative collaborators that have helped us throughout the session, and especially those who serve on the council, Chair Leach and Representative Smith and Senator Zaffarini and Senator Creighton. We're just deeply grateful for all of the work they do in trying to advance the council's recommendations in the legislature. So we couldn't do it without them. Thanks, Megan. Next, we'll turn to the regional presiding judges' salaries. The council is obligated by statute to set salaries each biennium, I guess. Yes. So Mena Ramon is going to report on that.
Thank you, Chief. Good morning. As the Chief mentioned, Section 74.051 of the Texas Government Code governs the salary for the 11 regional presiding judges of the state. As you're aware, these judges are appointed by the governor to serve 4-year terms, and they can either be an active district judge or a former or retired judge with district court experience. So for the retired judges, 74.051 sets out a salary based on the number of judges in the region. But for the active judges, that is set by the council every biennium. And the only limitation in 74.051 is the maximum salary is 30% of a district judge's base salary. And that amount comes to $42,000. This current biennium, it is currently $42,000. And I believe, just to give you numbers, 7 of the presiding judges right now are active, and 4 are active and 7 are retired.
Any questions of Mena?
Chief Justice, this is Judge
Yes.
Well, I so move.
All right. Is there a second?
Second.
Yeah. Any other discussion?
Chief, can I just verify that the Judge Gravel's motion is to set it at the same level as it is now, the 30%? Is that, just want to verify that's the motion.
That is correct, Mr. Slayton.
Okay, thank you.
Any other discussion? Is there any objection to the motion? Then it will be adopted by acclamation. Thank you, Judge Gravel.
Chief, I'm sorry to interrupt. Do I need to abstain from that since I am one of the presiding judges?
You're welcome to.
All right, I probably should do that. Thank you.
Yeah. Although who would know better than you how much you should be paid?
That's true. Thank you. Especially in the last year for the pandemic, right?
Well, and I will say that, the presiding judges have important jobs no matter what, but they went from meeting fairly infrequently to meeting several times a week, sometimes during the pandemic. And we just could not have survived as well as we did without them. I mean, they have just turned to every time an issue came up, helping their local courts try to meet challenges. I mean, it's really been impressive. And I've told everybody in the country, our presiding judges have really done a remarkable job. So thanks to you, Judge Madera, and your colleagues.
Yes, thank you, Chief. I appreciate that. Thank you.
Next is implementation of the CPS reporting requirements. Jeff Burkhart and Wesley Shackelford.
Thank you, Chief. Good to see you all again. The 86th legislature passed SB 560, which required for the first time that the Office of Court Administration start collecting data regarding child protective services cases. There are 2 types of reports that are required. One is an indigent defense expenditure, a CPS expenditure report. So this is collecting the expenses that are spent on CPS cases. And the other is CPS plans. The bill was actually modeled on the Fair Defense Act. So this is very similar to what we collect on indigent defense, but just for child protective services cases. The Office of Court Administration asked if TIDC would be willing to help collect this data since it's so similar to what we already collect regarding indigent defense. And OCA TIDC created a staff team to take a look at this, and that included Dylan Mensch from the Children's Commission, who I think some of you know. The plan right now is to phase this in over a few years. I think our concern in part is we didn't want to create reporting requirements that were too onerous for the counties or the judges involved in this at first, and really just make sure that folks are used to reporting the data and to support them as best we could. So as far as that 2-phased plan, I'll talk about the expenditure reports and what will be required there. I'll then hand it over to Wesley Shackelford, who can talk about the CPS plans and what will be required for the plans. As far as the expenditure reports, in phase 1, it'll be summary level reporting of the amount spent on child protective services representation by category. For instance, how much is spent on attorney fees, social workers, et cetera, as well as collecting the total number of cases by court. The information shared with the county auditors last year, so we basically have been communicating this to county auditors so they're familiar with this. They know they'll be required to report this. And we've been doing training at the auditors conferences so that they're prepared to report expenditures for CPS cases. So that'll be phase one. Again, phase one is really just summary level data, and that will be reported this November 1st. Phase two, we're going to start collecting a couple years down the line, or 1 year down the line, more detailed reporting. So next November 1st in 2022, detailed reporting regarding the categories of cases for which representation is provided. So that includes custodial parents, children, children's appeals, and things along those lines. So that's expenditure reporting in kind of a nutshell. Again, this November 1st will be summary level data. Next November 1st would be more detailed data. And then Wesley, do you want to talk about the CPS plan reporting?
Sure, thanks, Jeff. On the judicial plan reporting, as with expenditure reporting, we're going to be building on a basic reporting system on the platform that we already use for judges to report their indigent defense plans. This is through our partners at Texas A&M's Public Policy Research Institute. And as with expenditure reporting, we're anticipating a two-phase rollout. The first phase is going to include a basic reporting, including things like the type of appointment lists that are maintained, the qualification standards to get on those lists, the system that's used for appointing counsel. Most places it's assigned counsel. A few have institutional or public defender systems for providing child protective CPS representation. And we'll also ask the judges to upload any forms that they use or other documents in the appointment process. The things that we would expect them to have are attorney fee schedules and affidavits of indigence, because they have to determine indigence for parental appointments. And in the second phase, which is—
Excuse me.
Yes, sir.
Excuse me. I'm sorry. This is Representative Smith. Wesley, I'm sorry. I can't make out what you're saying. I may be the only one, and if so, I apologize, but I suspect I'm not. So we want to hear what you're saying, and I apologize for interrupting, but I just couldn't make it out. There's something going on with the technology there.
I'm not sure if anyone else can hear me. I can try and speak louder. I haven't generally had issues on Zoom. People seem to mostly—
Judge, are you good?
Hear me. So, okay.
Okay. It's probably just me then. It may be my technology. I apologize for interrupting.
No worries, Representative Smith. Well, you made me nervous there. Well, so phase two, I will talk loud, is the judicial plans mirror the indigent defense plans. They're due every 2 years, November 1st following legislative session. So the next one won't be due until November 1st, 2023. And we anticipate developing a more comprehensive system, especially after we bring aboard a new senior policy analyst with expertise in child protection cases. We've never had that on staff. And we have Crystal Left-Pignon starting next month, and she will lead the project forward. That's really something we've been lacking and why we've relied on Dylan with the Children's Commission so much during this interim period. We're also going to be developing a whole new system with our PPRI partners to update our technology, and the child protection judicial plans will be developed as part of that new website and technology update. And with that, I'm sure Jeff and I'd be happy to answer any questions you have.
Sure, and Wesley, I'd add just one more thing about why this is so important. We've collected this sort of data for indigent defense for about 15 years now, and it's made a really big difference. We've had great transparency about how indigent defense is delivered in the state of Texas. It's enabled us to get funding at the state level for indigent defense. It's enabled a lot of improvements over the past 20 years for indigent defense. But we've never had this data for CPS, and we don't really have that transparency for CPS cases. We think this could make a really big difference, so we're pretty excited about it. But yeah, happy to take any questions that you have about it. And I apologize, I have my youngest daughter, my 4-year-old, is in the room with me running around, so I'm sorry in advance for any background noise.
I just want to say that I think that this is really way long overdue. As one who does appellate work, presiding over child protection cases, the quality of the representation has been lacking. So I so gratefully recommend that we continue with this.
Anybody else? Yes, Senator.
I absolutely agree how important it is. Some of you who were members of the commission of the council years ago may remember that we addressed this very issue. And the problem that we had regarding the lack of reporting, even though there was a Supreme Court order for the judges to report their appointments. And we passed legislation, and I believe it's made all the difference in the world. We did not include CPS at the time. So this will result in more transparency. But what we found years ago when we first addressed this issue was that certain judges, including one in my hometown, were appointing the same people. It was just a small group of people. There was the court I'm thinking about, for example, if I recall correctly, a very small group of judges had 90% of the appointments. So it was really a source of income for specific attorneys, and then others had no ability to be appointed. And so I think that this data will result in transparency and in greater fairness of appointments. So thank you for that work and for following up on it. And David, you might want to add to that.
Chief, can I just add one little brief thing?
Please, yes.
I think another real value to this, just for your benefit, in addition to sort of the transparency and perhaps improved representation, is there's no way at this point currently to determine how much money is being spent by counties on CPS representation. And at this point, 100% of that cost is borne by counties. And the counties keep complaining, saying this cost is actually increasing faster than criminal indigent defense, but yet there's no way to quantify that. So this will be the first time ever that we will actually, after November 1st, if everyone reports, we will know for the first time ever, how much are we spending in the state related to representation in CPS cases, where the government is bringing the action, but the counties are required to appoint counsel for a number of parties in those cases. And I think the thought originally when this bill was passed was that there would be some consideration about should the state be picking up at least some portion of this, similar to the way they do criminal indigent defense. But without any numbers to know what the counties are spending, it was kind of hard to even take a shot at that. So this will be really valuable in future legislative sessions and just from generally knowing how much is being spent everywhere across the state. So I think that'll be a huge value.
Yes, Judge.
I was just going to say on behalf of the judges who now need to implement these things, it's not as simple as you might think. As they mentioned, our auditor heard about it before we knew about it. It will require changes with IT for our electronic pay sheets. There were some legislative changes this session relating to when and how attorneys are appointed and when they have to pay back their attorney fees for appointed attorneys. Again, it's going to be a big project to figure out how to change all our forms, how to change our IT, how to change all of our stuff to comply. So I would just say, if a judge is not, on November 1st ready to go, it may not be because of malingering. It may be because this affects a lot of departments that you wouldn't necessarily think about.
And Judge, I think that's an excellent point. We did have a couple of different groups, a group of auditors as a focus group and a group of judges for a focus group, and definitely got that feedback loud and clear. And I think that's why we wanted to phase it in and require kind of summary level data at first and then go a little bit deeper. We have been working on draft forms, vouchers and things like that can be implemented, but absolutely, we know it'll take a little bit of time to kind of get where we need to be.
Yes, Jim. I'm sorry, John.
Thanks. We'd gone through a thing with our auditor and they were tracking it separately from us. And so if you work with your clerks, we put it into the case management system and they just get it as part of their audit, and it's pretty automated. So it's a pretty easy way to get it done.
Other comments? Then Jeff, do you have a motion to adopt the implementation strategy?
Yes, Chief, I believe we do. Wesley, do you have the language?
I think Wesley, you're muted, but I think the motion, we were wanting to see if the council would adopt, the bill requires the council to adopt a plan, an implementation plan. So the motion would be to adopt the implementation strategy for reporting CPS data that was in the memo and the reporting book and in the meeting materials and has been discussed this morning. So that's what we're looking for.
So moved.
Second.
Any discussion? Any objection to the motion? It'll be adopted by acclamation. Thanks, Jeff and Wesley, very much.
Thank you, Chief.
Input. On new business, I'm just going to give you kind of a summary of the work going forward, and we'll have more details shortly. But part of it is kind of waiting on to see what the session produces. But as a reminder to the veterans here, the longtime members, not the military veterans. The work of the council is done through its 4 committees on civil justice, criminal justice, data, and public trust and confidence. And those have been the committees for a while. We can add committees if we need to, and I welcome your input on that. But I think most of what we need to do going forward can be done through these committees. You're certainly welcome to be a part of any committee you choose, and may have to ask some of you to help out in a particular area, but please feel free to express your preference, and we'll survey you here again, as I say, shortly. The goal of all of this is to produce recommendations for the next legislative session. That's one of the goals. So we'll be looking for a report in June so that the council can discuss the recommendations and begin to draft legislation that we will then get sponsors for as we approach the 88th session. The kinds of things that we'll be talking about, I hope, will be innovations that the courts have employed to survive the pandemic and keep going, and also improve our own processes. We want to learn from the distress that we've gone through and come out stronger on the other side. So we'll be looking at lots of things like remote proceedings, eviction, diversion, and so on. The bill that Megan mentioned earlier that would have addressed some legislation involving remote proceedings, the failure of that bill to pass doesn't hamper our efforts. It just didn't pass. So we still move forward. And we're the Supreme Court is very active in this issue already. We already have a task force chaired by Chief Justice Christopher in Houston that has undertaken to identify all of the statutes that exist that might impact how remote proceedings are conducted. So I know Judge Miskell's done a lot of work on this, Judge Ferguson out in West Texas, others, and are already coming together with processes that we can then begin to put together so that we can train judges on how to do it. So that's one area that we want to look at. And as I say, there's already a lot of people involved in working on this. I hope the bail reform bill passes, and it looks hopeful. And if it does, we will need to do several things to implement the bill, and that may need to be done sooner rather than later. So there are a number of aspects of the legislation that are going to require some implementation and input. So we'll be working on that. We're going to continue to monitor the border magistration issues, of course, and the uniform case management system. We're going to continue, of course, to improve the reporting of case level data. We need to, I feel like our actions to address racial justice have kind of stalled during the pandemic. And I take some responsibility for that because I was working on that pretty hard last winter, and then it just got to be too much. But in the meantime, the National Conference of Chief Justices and the Conference of State Court Administrators has formed a group that they call the Blueprint for Racial Justice. And it has a lot of people involved in it from across the country. I co-chair one of the 4 working groups that are involved in the project, one on systemic change, and we have about 40 people involved in that. So we've already done some work. The council's already done some work on these issues, and we just want to continue and make sure that we're actively addressing them in constructive ways. We've done some work on that through the public trust and confidence, so we'll be continuing to do that. And then we'll need to address other issues, maybe in civil justice, maybe in criminal justice, like backlogs. This is apocryphal, but a new board member of the National Center for State Courts, who is a plaintiff's attorney from Massachusetts, told me at our board meeting several weeks ago that the courts are getting blamed for the backlogs, and it's not fair, she admitted, and we're working as hard on it as we can, but I do sense that there is some of that, and there's a feeling of frustration that things aren't moving more swiftly, and like somebody said one time, everything's got to be somebody's fault, so it might as well be ours. We just need to make sure that we're addressing that proactively. The problem seems to be much worse on the criminal side right now, but the civil side is struggling as well. So those are issues, and there may be some others, and you're welcome to suggest them either to me or in your committee. We'll give you some kind of general charges, but we certainly want your input in what you should be thinking about and working on. So we'll get on that right away. We're kind of hesitant to do it this morning because we're still waiting to see what happens in the legislature, but we will do it soon. And those of you who have been involved in this process before know that you can schedule meetings and begin to talk about ideas and work toward having something to report next June. What have I left out, David? Oh, Senator, yes, please.
Yes. A couple of comments, if I may. First, regarding the virtual hearings legislation, Megan was very politically correct during her report, but the fact of the matter is that the problem in passing that legislation was not in the House. We had House members who were playing leadership roles in passing that legislation. The problem was full square in the Senate. And it wasn't so much the content of the bill, it was the issue of the bill. And there are just some key members of the Senate who are very, very passionately opposed to virtual hearings, not only in criminal cases, but in any cases. And so we will continue to work on that. And I'm delighted to hear you say that you will continue to work on it. I know that many of us believe, well, you would address the issue through court order if we couldn't pass it through legislation. So I'm glad that you have that option. And then second, regarding committees, having been experienced in working with the council and passing the legislation, we do our best when we know about the legislation as the recommendations are developed, and even before they're developed, as people are heard in the committee hearings. So may I respectfully suggest that you ask the committee chairs to always inform the legislative members of the Texas Judicial Council when committees are meeting, so that if we cannot participate, our staff can. And then we, the legislative members of the Judicial Council, will do a better job going forward. And if we know of potential barriers, we can inform you at that time. So I would respectfully make that request. And then third, regarding social justice across racial lines, I would also hope that you would make that racial and ethnic so that we can include Hispanics and others, not only a racial issue, but racial and ethnic. Thank you.
All right, thank you, Senator. Anything else? Did I leave anything else out, David?
No, sir, you got it.
Any other comments at this point? Okay, well, we'll get an outline to you and set up the committees, and you're welcome to volunteer and offer new ideas, and we will look forward to getting to work here fairly quickly. Anything else to come before the council? Well, there is one other thing. We're losing David Slayton. David is going to be vice president in the National Center for State Courts and doing the same strong work for the country that he's been doing for us. When David made this decision a couple of months ago, and when he told me about it, I was chairman of the board of the National Center for State Courts. So I was the president's boss. And when David told me that the president had offered him this position and he'd taken it, I immediately emailed her and told her she was fired. And she immediately emailed me back and said she understood there was a vacancy in Texas and she wanted to apply for it. So our very great loss is the country's gain, and we're proud of David and wish him well. I told the Conference of Chief Justices last month that sometimes it's hard for men to use the word love. Sometimes they're afraid of what that connotes, or they might be misunderstood. So I wouldn't go there myself, but I would say that the Supreme Court loves David Slayton, and I concur. So we are deeply in his debt for all the work he's done for us. We have a resolution that I want to propose to the council to adopt, and I'll read it to you. It'll take me a minute, but it expresses the respect that we have for David. It reads, whereas in October of 1998, David Slayton began his distinguished career serving the citizens of Texas, first in the courts and district clerk's office of Lubbock, then in the federal district courts of Lubbock and Dallas, and later as the director of court administration for the Lubbock County Administrative Office of the Courts. And whereas on May 12, 2012, David Slayton was appointed administrative director of the Office of Court Administration by the Supreme Court of Texas, and in that capacity also serves as the executive director of the Texas Judicial Council. And whereas during the last 9 years, David Slayton has worked tirelessly to improve the administration of the courts and provide the technological resources necessary for the efficient administration of justice, and established longstanding relationships with the state's judges and policymakers. And whereas during his tenure, David Slayton worked with the Texas Judicial Council to ensure that judicial issues requiring legislation and the attention of the council were addressed, including the council's initiatives regarding juvenile justice, school ticketing, mental health, bail reform, court costs and collections, and court and judicial personnel security, to name a few. And whereas during the COVID-19 pandemic, David Slayton ensured that the state's courts had access to the technology and technical support necessary to continue operations remotely, and had the guidance necessary to ensure that both court personnel and the public could participate in the state's court system in a manner that was safe. And whereas David Slayton has served in many leadership roles in several judicial administration groups, including as president of the National Association of Court Management, member of the board of directors of the Conference of State Court Administrators, co-chair of the Conference of State Court Administrators National Association for Court Management Technology Committee, leader of the Post-Pandemic Planning Technology Working Group of the Council of Chief Justices and the Conference of State Court Administrators Rapid Response Team, and publications chair of the Texas Association for Court Administration. Again, to name a few. And whereas on August 31st, 2021, David Slayton will leave his position as Administrative Director of the Office of Court Administration to continue his work in improving the courts and delivery of justice at the National Center for State Courts, and his leadership, dedication, and inspiration will be missed. And whereas the Texas Judicial Council wishes to recognize David Slayton for his invaluable work, leadership, and contributions during his tenure as Administrative Director of the Office of Court Administration, now therefore be it resolved that the Texas Judicial Council extends its sincere gratitude for the outstanding service of David Slayton and wishes him the best as he pursues his new position assisting state courts across the country. That's the resolution. Is there a motion to adopt it?
So moved.
Any questions? Any objection? It's adopted by acclamation. David, any response?
Thank you very much. Chief Justice has seen me do this a couple of times. I'm going to try to make it through this one without crying, because every time that this is, I received an honor at CCJ Costco, which I blubbered through, and I called the chief and told him I was moving. Or moving on. I blubbered through that. So what I would just say is thank you so much for that very awesome resolution. I really do appreciate it. It's been the honor of my career to work with this group, and as you look back and as I look back at the things that the Judicial Council has done, there are many Texans and many people using our justice system who are the beneficiaries of our work, and will probably not know that this group is the one who was behind those changes. And as the chief mentioned in the resolution, you know, those things, whether it be school ticketing or truancy or mental health or fines and fees, you know, bail, whatever it may be, the work that this council has done has been such a pleasure for me to be a part of, and working with each of you in your individual capacities, and the former members of the council who are no longer with us. My relationship and the opportunity to get to work with you has been absolutely terrific and a highlight. The good thing about moving from this position to the new one is it's not like I'm going to work for some private company somewhere that has nothing to do with the judiciary. The good thing about this job is it is now part of my job starting September 1st to work with you. That is part of my obligation. It will be in a different role, but I'm happy that I'll get the chance to work not only with you, but with the state courts of across the country and sometimes around the world. So I take with me all the things that I've learned from you. I will have a really hard time not telling everybody how awesome Texas is, because, you know, people get sick of hearing about that. But I really, truly am grateful for the opportunity provided to me by the Supreme Court many years ago. They took a chance on a young guy that said he could do some things, and I'm grateful for that. I'm grateful for the opportunity to work for Chief Justice Hecht. That's where I should stop talking about that, but it's been a pleasure. Thank you very much.
Thanks, David. I hope council members will be discreet in commenting on the decline in the quality of leadership of the council because of David's departure, and we'll attempt to do our best. But we don't have a next meeting time for you at this point, but we'll get one out to you shortly. And if there's nothing further, I'll entertain a motion to adjourn. Any objection? We're adjourned. Thanks.
Thanks, everybody.